Bob Kerrigan for Kerrigan, Estess, Rankin, McLeod, and Thompson. And in this short video today, we're going to talk about the waiver of sovereign immunity. What does that mean, sovereign immunity? It means that the government, the United States government, the state government, the county government, municipal governments, and their entities and affiliated businesses are immune from suit. That is, you can't recover damages against them unless it's specifically provided by Florida law. At common law that we derive from England, you couldn't sue the king. Nobody could bring a claim against the king. And we adopted the common law in the United States, and for many, many years, no claim could be made against the government, regardless of the wrongdoing of the government. Well, now, in more modern times, we have a waiver of this immunity called a waiver of sovereign immunity, and it's provided by Chapter 768.28, which I'm reading from now. For those of you who like to Google this and look at it yourself, it's 768.28 Florida statutes. Now, this is just for Florida. Doesn't apply to the federal government, and it doesn't apply to any other states. It's just the Florida state government, the state of Florida, municipalities, counties, and governmental organizations of the state of Florida. The state and its subdivisions, as this statute provides, shall be liable for tort claims. What are tort claims? Tort claims mean civil claims for damages based upon an injury or a harm that's been caused by the government in the same manner and to the same extent as a private individual under like circumstances. So if a municipal employee does something, drives a car recklessly or whatever, and causes an accident, the municipality is legally liable, just like an ordinary company would be if their employee caused an accident. But liability shall not include punitive damages. Punitive damages are punishment damages, and the waiver of sovereign immunity does not allow a suit for punishment damages against a municipality or any county or the state of Florida government. The waiver of sovereign immunity is, however, conditional on certain amounts. In other words, it isn't unconditional. If you obtained a judgment against a private corporation for $500,000, that is not permissible against the state or municipality or the counties of the state of Florida. It is what they call capped, meaning there's a limit on the recovery of $200,000 per claim or $300,000 for all claims arising out of whatever the tortuous or action was, negligent action that caused the injury. For example, let's go back to the illustration of an employee of the municipality driving a car and causes an accident in which 4 people are injured, and 2 of them are very badly injured and 2 not as bad. The total that the municipality would have to pay among those 4 is $300,000, and no one individual could obtain more than $200,000. Now, filing claims against the state, the county, and the municipalities has some tricks in it, in the legislative parlance here, that if you're not familiar with it and you don't know what you're doing, you can lose your claim. You must notify the agencies of the municipality within 3 years of the date of the alleged activity. And normally it might be 4 years. In fact, the normal Florida statute of limitations for an automobile accident is 4 years. And for other injuries, other than medical malpractice, is 4 years. But against the state or any of its agencies, you must make that claim within 3 years. And in addition, the claimant must present the claim, this is subsection 2, in writing to the Department of Financial Services within 2 years after the claim accrues. That's for accidental death. So that's limited as well. As an injury claim, it's 3 years. And then there is a 6-month notification that must be made before a lawsuit can be filed, and that allows the governmental agency to review the circumstances of the claim and determine whether or not they're going to settle. So what are the limits? You must notify the governmental agency 6 months before you file claims. You must bring suit within 3 years the date of the injury, if it's an injury claim, and you must bring a claim against the state and the Department of Financial Services by notice within 2 years of the date of a death. Sovereign immunity is waived in Florida under 768-28, but there are conditions of that waiver that a lawyer must be familiar with and must prosecute the claim appropriately, or the claim will be lost. Bob Kerrigan for Kerrigan, Estess, Rankin, McLeod, and Thompson. We're board-certified specialists with an expertise in civil trials and civil claims. So contact us or check us out on our website at kerrigan.com.